Counsel, this case is set for 10 minutes. How much time do you want to reserve for rebuttal?
I'd like 2 minutes, please.
Okay, you may proceed, and you know how the light system works.
Good morning. Jeffrey D'Souza on behalf of Eric Lewis. May it please the Court, Rule 3.190A states that every pretrial motion and pleading, quote, shall be in writing. And that might explain why my client, when he sought to obtain substitute counsel based on pretrial ineffectiveness, alerted the judge to that request in writing. His motion was docketed the day after it was filed, but the trial judge never ruled on it, which means that as a result, under the waiver rule applicable in this district, and I believe in this district alone, his otherwise meritorious Nelson claim is not cognizable. What we are asking the panel to do is acknowledge that the standard of review in cases where there is absolutely no Nelson inquiry at all is structural error, and as a result, that development in this district's law allows the panel to revisit the waiver rule. Alternatively, we are asking the court to recommend to the en banc court a review of the case.
Is this issue preserved?
Well, I think that goes to what we're calling the waiver rule, this court's decision like Kinsey. The reason that we believe it is preserved is because, number one, if you look to the rules of criminal procedure like an incarcerated pro se litigant might, and my client is treated as pro se for the Nelson purpose, if you look at 3.190A, it says file your motions in writing. So that is, I think, pretty clearly telling particularly an incarcerated litigant who may be not capable of researching case law but has the rules in front of him, here's how you properly preserve a pretrial motion. You put it in writing. And there have been a number of cases where trial courts have looked at written Nelson motions, denied them in chambers, and that is perfectly acceptable. But I think that is what you would expect of a trial judge who has a pleading pending in front of him.
Are you saying that the judge must make a ruling on a written Nelson motion, or written motion sort of along the lines of Nelson?
Judge Force, assuming that it's facially sufficient, which we believe that this motion was, then yes, a judge has the responsibility to rule on a written motion. And I would point you to the 5th District's decision in Boaz, where the court at least impliedly recognized that putting in a letter your request for a Nelson hearing is just as good as apprising the judge orally. And I think there are good reasons of that. As I've said, the rule says put it in writing. And I would note parenthetically, after the trial in this case, after the sentencing was done, before the trial in the severed count, defense counsel brought to the attention of the trial judge the fact that my client wanted to discharge counsel under Nelson. And of course, the trial judge's response was, put it in writing, direct quote, put it in writing. So I think judges understand that they are responsible for ruling within their dockets on written motions.
Let's discuss the sufficiency of the motion, though, because, after reviewing the motion, it seems clear that he was wanting to discharge counsel. But I'm concerned about what in the motion can you point to that seems to explain what's the alleged incompetence. I mean, there are a lot of general statements, he didn't talk to me, didn't prepare a defense, but nothing specific. So I'm concerned about the legal sufficiency of the motion that justifies having a Nelson hearing even in the first place.
Judge Conner, what the rules say is that to be a legally sufficient motion, you must allege that you want to replace your court-appointed counsel.
Plus, you have to allege something about what's the incompetence that's the problem. And the case law seems, pretty clear that you can't just generally say he's not talking to me, he's not working hard enough on the case, he's not preparing, a defense. That is too general under our case law. So,
Your Honor, I think what you're referring to is when a preliminary hearing actually happens. When the judge asks, is it an unequivocal request, and if it's unequivocal, is it based on ineffectiveness? That's what's supposed to happen at the preliminary hearing. But to trigger the requirement of the hearing, all we need to do is allege, Judge, I want to change my lawyer for some reason, and that triggers the requirement that the judge come in and inquire further.
I'm troubled by the fact that the defendant files a motion months before the trial. Let's assume for argument's sake, and only argument's sake, that the motion is sufficient. My lawyer has not taken a deposition in this case. He has not come to talk to me about the defenses that we're going to present. Months go by, the motion's now pending, the judge doesn't know about it or hasn't set it down. You start the trial, the judge inquires of the defendant, anything else you want to present, you satisfied with your lawyer, and to those questions, they all suggest, the answers suggest totally satisfied, all of the things that implying all of the things that I complained about months before have been rectified. Your suggestion is that notwithstanding that, this judge now has to go through the process of a Nelson inquiry. Is that what you're asking us to do?
At the outset, a factual point, it was 6 weeks. I'm not sure how much it matters to Your Honor. It's 6 weeks. The reason that we don't think that this colloquy that happened, if you can call it a colloquy, is not sufficient is if you look at the cases that actually held that the issue was mooted by an expression of satisfaction of counsel. I wrote some of them down. Sweet, there the defendant, quote, spontaneously pronounced his satisfaction. In Skull, he said, quote, it could not have been done better. Thompson, quote, yes, I do, everything. I'm okay with everything. This is a little bit different. I think if you affirmed on that basis here, you would effectively be requiring my client to take a futile act, because the colloquy happens right before closing arguments and the charge conference. So at that point, there's really nothing that can be done insofar as my client complaining about pretrial ineffectiveness. That ship has sailed. And I think my client rightly believes that if he's filed the pretrial motion in writing as he's supposed to 6 weeks earlier, and there's been no action on it whatsoever, I think he reasonably infers that the reason for that is because the trial judge did not believe he was entitled to Nelson relief. I would also note on the point of mootness that after the trial in this case, as I mentioned earlier, defense counsel brings to the trial judge's attention that my client wants a Nelson motion. He wants to do a hearing to look into my ineffectiveness. So my client certainly does, at least after the trial, still maintain that defense counsel pre-trial was ineffective.
But I'm still concerned about the point that Judge DeMorgian is concerned about, and that is he raises us all at the end, so to speak, after he knows the outcome. It's certainly not uncommon for pro se or for defendants who are represented by counsel who may not be happy with them during a break or a recess during the trial, particularly at the beginning of voir dire before the jury actually comes in, for the defendant to make some comment out loud where the judge could hear it, I'm not happy with my lawyer. And that certainly apparently did not happen in this case. So, it does suggest to some extent that he was kind of hanging back to wait and see, let's how this unfolds, and then if I need to use it, I will.
It's an inference that could be drawn, although I don't, again, he files it pre-trial. So it's not as though he hasn't brought this to the court's attention in precisely the manner that outside of this court's decisions like Kinsey, he is supposed to. I would also note, number one, that this is a pro se litigant, and the courts have traditionally shown some leniency in technical matters for pro se litigants. I think that should weigh in the balance. I also think that as a policy matter, the waiver rule does to some extent encourage trial judges to ignore these pretrial motions. And we don't say that to demean trial judges, but I think it's just a point of human nature that if somebody's not pressing you to engage in this very sort of difficult, thorny IAC inquiry, you may not do it to see if they later raise the issue. So institutionally, I think the system has an incentive to encourage trial judges to deal with potential IAC claims up front at the point where you can deal with the IAC rather than either run the risk of a potentially erroneous conviction or you run the risk later of incurring systemic costs because now you have lengthy, costly 3850 motions, federal habeas.
Thank you. You're in your rebuttal time.
Thank you very much.
I'll give you a minute. May proceed, counsel.
Thank you, Your Honor. If it pleases the court, my name is Ilana Mitzner. I represent the Attorney General's office. Just to address very quickly what counsel started with, we don't think that this was preserved. It was not brought up in front of the trial court. The case law is clear, especially coming from the Florida Supreme Court in Sweet v. State and in Skull v. State, where it states that if the defendant does not bring it to the trial court's attention, then it's essentially waived. And as far as the other districts following the per se rule, that's actually incorrect. If you look at all the cases that were brought up by Lewis in his initial brief, those were all cases that were factually distinguishable from the case at hand. And then if you look at the motion itself and the certificate of service, he did not actually serve his own counsel. He served the public defender. Public defender and regional counsel had both conflicted off the case. He was court-appointed Mr. Fernandez. So Mr. Fernandez could not have known about it because he wasn't actually served with the motion. It also says that the state attorney's office was served. The state attorney's office, in all likelihood, was never properly served either because they never brought it up. If they had been served with it...
That's a pretty big inferential leap. Is that in the record anywhere?
No, Your Honor, it's not.
Well,
But
Well, and let's talk about this business of notice, though, because, you know, the law frequently imposes a notion of constructive notice, and certainly I think it's not unusual for trial judges to hold attorneys responsible for knowing what's been filed in the court file. So address the argument that the trial court was on constructive notice of this motion just by the mere filing of it.
well, Your Honor, even if they were on constructive notice, the case law is very clear. Even being on constructive notice, the case law states that the defendant has to bring it up to the trial court. That hasn't changed. It's the law from the Supreme Court, the Florida Supreme Court, has not been overturned. The case law from this court has not been overturned. In fact, other districts have quoted and cited 2 cases from the 4th DCA. In fact, in Thompson, from the 1st DCA, they cited back to Sheffield v. State, which was decided by this court, and that case is particularly on point, and that's where the defendant filed a pro se motion, never brought it to the court's attention, went to trial, and expressed general satisfaction with his attorney at the end of trial. Also, Your Honor, if you look to the record, Lewis had numerous opportunities to raise this issue to the court. There were 2 pretrial hearings on May 14th and May 18th before trial started in which the court addressed Lewis. He never said anything. At the May 18th hearing, the court spoke directly with Lewis to make sure he understood his rights. They were having a conversation. He never said anything about his attorney at that point. Then there were 2 instances where the trial court, before trial started, where the court addressed Lewis directly and asked if he was satisfied. The first one was at the end of jury selection, and the next one was before trial started if he wanted to bring anything to the court's attention. So he had those 2 opportunities before trial even started to bring to the court's attention his dissatisfaction.
If he had, at the point where the judge questioned him, are you satisfied with your attorney? If he had said, hey, did you get my motion or something like that, what should
the court should have then inquired about the motion and, according to the case law, conducted at least a preliminary Nelson inquiry to find out exactly what his problem was. And after doing that, then the court can determine if a further Nelson hearing is required or if the motion itself is just a motion of general dissatisfaction without any specific allegations of incompetence.
If he had repeated the allegations that were in his motion, would it have been sufficient to?
The state's position is that it wouldn't have been, Your Honor. The motion that he used was a boilerplate motion. It didn't allege anything specific as to what exactly he had done wrong. Just, he didn't keep in contact with me, he's not doing a proper investigation. It didn't say what investigation, it didn't say the type of contact that was made, that he didn't reply to. It didn't say what motions he failed to file, what witnesses he failed to speak to. In fact,
So what about the defense argument that, you know, as long as he put it in writing, at least generally, that triggers some kind of responsibility for asking the defendant, tell me more what you're talking about?
it's only if it comes to the court's attention, Your Honor. Again, the case law is very clear about that. In fact, there's one case, I believe it was Campbell v. State, where the court actually denied the motion in chambers, stating that was facially and that motion was facially sufficient, and the defendant wanted to dismiss his counsel based on a detailed claim of incompetence. However, I'm sorry, Your Honor, because it was facially sufficient and it was denied without a Nelson hearing, it was sent back to the lower court to conduct the Nelson hearing. So, Your Honor, as soon as it comes to the court's attention, yes, some sort of Nelson hearing has to be made. And in each one of the cases that is cited in his initial brief, it's clear that it's distinguishable from this case either in that the court didn't know about it or the court knew about it and failed to conduct a preliminary Nelson hearing in at least that before ruling on the motion.
Did the judge, you mentioned there were actually 2 occasions where the judge inquired of the defendant whether he was satisfied, and you weren't specific on the one I'm familiar with is at the end of after closing. But the one that you mentioned, I thought that was a general statement about are you satisfied with the jury selection process?
Yes.
The judge at that point didn't say, are you okay with your lawyer at that point?
That's correct, Your Honor. However, it would have been an opportunity for the...
I get that, but my question is there was nothing that the judge did not at that point. The jury, that was the judge's inquiry, the defendant at that point was primarily about the jury selection process and the jury itself, the composition of the jury.
Yes, Your Honor. That is correct.
And then the second occasion where the judge addressed the defendant directly, in that occasion, the judge specifically said, you satisfied with your lawyer?
Yes, Your Honor. That was right after the trial concluded, before it was sent to the jury.
Right, okay.
Which would still give him the opportunity to say something before it was sent to the jury. Yes, a mistrial would have been declared, but at least...
Does it make a difference that the judge specifically inquires of the defendant whether the defendant's satisfied with his or her lawyer, as opposed to general questions regarding, typically you have the right to testify, the Fifth Amendment privilege, and putting the defendant on notice about testifying or not. Are you okay with the jury? Is there any other evidence you want to present? Versus, are you okay with your lawyer? Should it make a difference?
It should not, Your
Defense
Honor.
counsel seems to suggest that it shouldn't.
It does not, Your Honor. According to the case law, in all the districts, it's only whether or not the defendant brings it to the court's attention.
But your case is clearly stronger if the judge specifically asks the defendant, are you satisfied with your lawyer?
Absolutely, Your Honor. On those facts, especially if he had done it before the trial started, but that's factually, yes, it would make the case stronger. But with the fact that he had these opportunities where the court addressed him directly, even if it was just to ask him about general satisfaction or dissatisfaction, he still didn't take that opportunity. He only brought it up after he was convicted and sentenced. And then once it was brought to the court's attention, then the court conducted a preliminary Nelson inquiry. And said, your counsel's fine, you don't get a new one, because it was just a general, it was just a motion of general dissatisfaction without any specific allegations of incompetence. And he essentially filed the same motion twice, both for this case and for the next case, the severed count that got tried not long after. So he didn't allege anything specific, and if you look in the record, his allegations are actually refuted, because there were motions filed. There was a motion to sever the offense. There was a motion to authorize a private investigator. There were demands for discovery. There were motions in limine filed. And when you look at the record of trial, there's nothing to indicate that he was ill-prepared or he had any general issues of incompetence. He zealously advocated for his client during that time. And as far as the waiver rule goes, Your Honor, we disagree wholeheartedly with Lewis's claim that the waiver rule allows the court to ignore Nelson hearings. We feel that to make that statement, it's jaded and it's unfair to the court. Lewis is making the assumption that the judiciary would fail to his assumption that the judiciary would fail to address these motions is unwarranted. In fact, if you look at one of the cases that Lewis cited in his reply brief, Wilson v. State, that court also stated it is not the job of the judge to become an advocate for the defendant. And in that case, the court conducted a preliminary Nelson hearing and found the defendant did not raise specific complaints or former allegations of incompetence, and this court affirmed that lower court decision.
You're out of
Yes,
time
sir.
in 4 seconds. One last statement, quick.
Just, we asked the court to affirm the lower court's decision.
Thank you.
Thank you, Your Honor.
1 minute, sir.
I think, to the mootness point, if you hold that his single word answer, no, which of course occurred after trial had already conducted almost the entirety of the trial, I think that would be requiring him to engage in a futile act. This is not like the cases where there's an affirmative expression of counsel. To the extent that he had said to the judge's question, yeah, here's my list of complaints, my friend has suggested that there then would have been a Nelson inquiry. I think that's a little unrealistic considering the point in time that the trial was occurring and the fact that had the judge found there was IAC occurring, the only remedy would have been a mistrial.
How
So
does this case differ from the Supreme Court's Morrison case in terms of, I was looking at his request for a different attorney, and it seemed like checking every box that Morrison said, that doesn't get you a Nelson hearing.
I think the difference is that you have to at least on the record address the claim. It's not enough that on the face, so if the defendant, this is CH from the 3rd District, the first step is the defendant has to allege simply that I want substitute counsel, and that's what triggers the hearing. Everything else comes later. So he gets his foot in the door on record page 79 when he says, I want new counsel appointed. At that point, it's on the trial judge to figure out what is the claim of ineffectiveness. I would leave you with one last remark. If it's your view that the panel cannot reconsider the waiver rule, we would ask that you certify conflict with Boaz, a case out of the 5th where there was only a written motion, and nonetheless, that case was reversed for a new trial. Thank you.
Thank you, counsel. All right, let's give these lawyers